For all the Jural Assemblies 53, the actual legislative history. April 26, 2019 by Anna von Reitz. Every once in a while the U.S. Supreme Court, or one of the U.S. Supreme Courts, there are 6 that I know of, and when they get into Star Chamber mode, there are probably a dozen, comes up with a golden nugget. Here's one dug out of the archives by Ed J. It is not the function of our government to keep the citizen from falling into error, it is the function of the citizen to keep the government from falling into error. American Communications Association v. Douds, 339 U.S. 382, 442, 1950. With that firmly in mind, and fully admitted on all sides, let's look at the actual legislative history underlying the current malaise. It all began to go off track during the Civil War, and specifically with the Enrollment Act of March 3, 1863. This came just a few days before Lincoln declared the Northern Confederation of States bankrupt, just before he issued the very first executive order as Commander-in-Chief, the Lieber Code, otherwise known as General Order 100. We have already discovered that the actual states of the Union did not participate in the Civil War, which was in fact not a war, but a mercenary conflict like Vietnam. The entities that fought this major conflict were all states of states, commercial businesses operated by the states of the Union, and they were all members of the original Confederation of States doing business as the States of America before the conflict. Wrap your head around that one. What took to the field in 1861 were all Confederate states of states, both North and South, were commercial businesses belonging to the actual states, in the business of providing essential government services to all the states. So, in a sense, this was a private war with public consequences. 1/3 of the mandated federal government, the federal part of it, disappeared as a result of the Civil War. The southern states of states were subjected to ruination by men like William Tecumseh Sherman, and the northern states of states were bankrupted by Lincoln. Our actual states were the staging ground for all this destruction, with our innocent civilian population being the true victims of it all. What remained was the other branches of the federal government, the British United States territorial government and the municipal United States government. Anyway, now you are prepared to take in who the actors were operating the Congress on March 3, 1863. These were the elected representatives of the northern states of states' commercial corporations facing bankruptcy. This backdrop prepares us for what happened next, the Enrollment Act. The Enrollment Act created a federal overlay of the United States on top of the actual United States of America and divided this new overlay into military districts, each one with a provost marshal working under the auspices of the Department of War. This original provost marshal position was very important, as it was the interface between the new military district government and the civilian population of the actual states. The provost marshals were then administratively charged with keeping the peace, coordinating military and civilian forces, the state national guards, militias, and local sheriffs and police to work with the active duty military, and to form a de facto military government. Lincoln would very shortly unveil the Lieber Code and set this in motion. We have been living in a state of emergency and under the thrall of a military junta ever since. But let us as the true citizens of this country stop a moment and take pause. Who did this to us? Our employees. And did they have authority to do this? No. The members of the Northern Confederate Congress of Commercial Corporations had no such power then or now, and as the United States Supreme Court has often noted, any law or legislation or regulation contrary to the terms of the constitutions has no force or effect, and is null and void as if it never was. We declare it all null and void. By operation of law, all powers assumed return to the states and people that delegated them to the British territorial United States government, the entity in charge of running our joint military forces, in the first place. By law, they are required to get back in their box. For now, let's resume our trek through the legislative history, bearing in mind that all legislation is law only for the internal purposes of the entities that pass such legislation. So we have ersatz military districts superimposed over our actual states and their actual governments as an emergency measure undertaken by the British territorial United States government and Abraham Lincoln working for them as Commander-in-Chief of our own armed forces, and each district presided over by a military official, a provost marshal, and no valid authority for any of this under the constitutions. This same untenable act of a Confederate Congress resulted in the Selective Service Act of June 24, 1948, 62 Stat. 604 and codified as Title 50, Sections 451 to 473. This means that every man subjected to the draft in World War II, Korea, and Vietnam, was presumed upon unlawfully and illegally. They were press-ganged, and press-ganging has been outlawed for 200 years. Moving right along, next, our military was placed under a similarly null and void piece of self-serving British territorial legislation proposed under Admiralty Law, an act to facilitate judicial proceedings in adjudications of captured property, and for the better administration of the law of prize, and this then was used to formulate Title 10, Section 7651-7681 of the Military Code of Justice. This statutory law was passed March 25, 1862 under the Insurrection and Rebellion Acts of August 6, 1861 and July 17, 1862, by the same Northern Confederate State of States Congress that pulled all the rest of this crap without any authority to do so. This law was purely meant to guarantee an excuse and orderly means to pillage and plunder our southern states under the pretense that they were states of states and that the states of states owned everything south of the Mason-Dixon line. That is all untrue, that this is all criminal, and all based on lies and false assumptions is just now coming out in the open for the American people to see and judge for themselves. This is the basis for the carpetbagger court system set up in the southern states after the Civil War. We will skip over the bankruptcy of the British territorial government in 1907 and all the skullduggery that happened then, and proceed apace to the Great Fraud of 1933, when the Roman Catholic Church's Delaware Corporation, doing business as the United States of America, Incorporated, went bankrupt. This version of the same banal evil was, get this, run as a religious nonprofit. You can't make this stuff up. Anyway, in 1933 they went bankrupt. FDR made his big inaugural speech about a holy cause without anyone outside Washington, D.C. having a glimmer what he was talking about, and they used this as an excuse to claim that they had given full disclosure to the American people, full disclosure about the greatest bankruptcy fraud and pillaging in world history, which FDR was about to undertake for his Holy Roman masters. Of course, they couldn't do this under the British common law, so they had to bring the British territorial United States under a form of law more conducive to our aims, and they found that in Puerto Rico, and British Commonwealth possession of the United States, where the Spanish law of the Inquisition still applied to slaves. Then all they had to do was steal our names and unlawfully convert them to the status of municipal United States citizens under the Territorial Diversity of Citizenship Clause found in Title 28. Voila, we, the free and independent Americans, were magically redefined by fraud to be municipal United States slaves, residing offshore and subject to the Puerto Rican Spanish law of the Inquisition. Well, you know what we say to all that? That was their conversion to the Spanish law of the Inquisition by the municipal United States government, the plenary oligarchy we gave to Congress and limited to the 10 miles square of Washington, D.C. Next, over the next few years, the municipal United States government had to overcome the British common law of the British territorial United States on shore, too, and that took some more doing. There they used an obscure case and a bizarre circumstance involving, once again, the railroads and their protected status, Erie Railroad v. Tompkins in 1938, to declare that there is no such thing as a general federal common law. What preceded then was a scramble to define a federal common law for the onshore municipal government. This was pursued through the Clearfield Doctrine coming out of Clearfield Trust Co. v. U.S. 318 U.S. 363 1943 and the United States v. Kimbell Foods 440 U.S. 715 1999. This is where they adopted the Uniform Commercial Code as federal common law, but more properly and exactly, as municipal United States common law. The British territorial United States operating the military districts continued under the common law of Admiralty. They got away with this in both cases because maritime commercial transactions, think merchant marine, are subject to the common law of Admiralty. See Interpool, Limited v. Char YIGH 890 F 2nd PG, 1453, 1989, in which municipal corporations are bound over to the Admiralty common law. While all these court and form of law manipulations were going on, and all of this, mind you, involves nobody and nothing but the foreign commercial corporations that are supposed to be on our shores delivering good faith governmental services, the two sides of this epic story of fraud got together and colluded to merge law, equity, civil, and admiralty under the federal rules of civil procedure. This happened in 1966. This is all expressed in Volume 324, page 325, of the Federal Rules Decisions, and what this all means is that our American common law is not available to us because it has been nested inside the Admiralty law by our dishonest, disloyal, and/or incompetent public servants. This is why Title 28 Section 1333(1) gave the municipal United States original jurisdiction. Please note this next phrase, underline it, pink highlights, exclusive of the states, for all cases of Admiralty maritime jurisdiction under the Saving to Suitors Clause, Article 3, Section 2, which gives the district courts of the United States judicial power in all cases of Admiralty and maritime jurisdiction. This is the only still standing Article 3 judicial power that the vermin occupying Washington, D.C. use, their very own little War Powers Act of Admiralty. Pretty good for a government that is supposed to exist only within the 10 miles square of the District of Columbia, and exists only for the purpose of overseeing and running the municipality of Washington, District of Columbia, as a meeting place for all the states and their various congressional delegations. This is why when you walk into a state-of-state court, you cannot get any remedy for their vicious lawlessness. This is why the only remedy there is on the high seas and navigable inland waterways, the common law of international admiralty, enforced by the military district government of the British territorial United States. But remember that little pink highlighted phrase? Exclusive of the states? That means us. The actual America and the actual Americans. Naturally, a foreign government cannot legislate for us. We bear the responsibility to govern ourselves. And also the responsibility to hold our run-amok foreign corporate service providers to account. They have conspired to bring Americans under the heel of their foreign laws and statutes by impersonating us. They have used undisclosed and unconscionable commercial contracts to do this. Both the British territorial and municipal United States authorities have been operating as crime syndicates on our shores, in violation of the constitutions which allow them to exist. This fact needs to be brought home with a sledgehammer upon the members of their Congresses, along with a fire alarm-style wake-up call to Americans. It is not the function of our government to keep the citizen from falling into error, it is the function of the citizen to keep the government from falling into error. American Communications Association v. Douds, 339 U.S. 382, 442, 1950.